Licensee responsibility for conduct of employees. Licensees are responsible for the conduct of employees and may be held responsible if their employees violate liquor laws on the licensed premises. Licensees may be held accountable for the criminal acts of employees, even if the licensee instructed the employee not to engage in the criminal activity or was not aware of the criminal conduct. To avoid the risk of a violation on their records, licensees must make a serious effort to be aware of what is happening at their place of business. Licensees must take necessary steps to prevent criminal activity by employees. They must also take immediate corrective action when they suspect criminal activity. To further minimize risk, for licensees who aren't ordinarily on the premises, these licensees should make occasional visits to personally observe activities of both employees and customers. It's probably a good idea to visit during all shifts and sometimes after hours. Licensees and permittees must prepare to act when they see red flags or indicators that some sort of criminal activity may be occurring at the business. A red flag could be a variety of things, such as syringes found in the building or parking lot, frequent trips by certain individuals to the restroom or parking lot, etc. A licensee or permittee may be subject to fines or suspensions if they know of criminal activities by coworkers and fail to take steps to deter or to report it. If a licensee or permittee suspects a problem and requests public assistance, the OLCC is less likely to hold them responsible or impose a severe sanction. Asking for police assistance, however, does not excuse licensees from the responsibility to personally monitor their businesses. Licensees should institute management practices and house policies to help avoid such problems. Unlawful activity. Just as licensees and permittees must take action when they suspect a coworker is involved in any criminal activity, they are also responsible for the actions of their customers. Licensees and permittees must not permit any unlawful activity on the licensed premises or in areas outside the premises that the licensee controls, including the parking lot. Unlawful or illegal activities include prostitution, public indecency, illegal gambling, or illegal drug use or sales in or near the establishment. In order to host legal gambling activities in their place of business, licensees must be sure the type of gambling they're considering falls into the lawful category. To determine which gambling activities are legal in their community, licensees should call their local district attorney. Orderly premises and neighborhood livability. Licensees and permittees are responsible for customer behavior which affects the neighborhood's livability. No licensee or permittee will permit on or in the immediate vicinity of the licensed premises noisy or disorderly activities. Noisy activities are those that a reasonable person would conclude interfere with normal living or business activities. Violations of state or local noise pollution standards may be considered evidence of noisy activities. Disorderly activities are those that harass, threaten, or physically harm another person. This may include abusive language, fights, or threatening behavior. Licensees and permittees are responsible for alcohol disturbances in the immediate vicinity of the business if the disturbances are related to the sale or service of alcohol. Immediate vicinity usually goes beyond the parking lot and may be as much as 2 or more blocks away from the establishment in some cases. Disturbances are defined as serious and persistent problems caused by customers who are noisy, disorderly, or involved in illegal activities. Examples: excessive noise, public drunkenness, unlawful drug sales, trespassing on private property, fights, alcohol or related litter, public urination. If an establishment has a history of serious and persistent patron-related problems, the licensee will receive a fine or other sanctions. Remember, the majority of licensees and customers do not cause problems for neighbors. Some licensees have occasional problems. Most often, prompt attention and cooperative efforts with the OLCC can help prevent continuing disturbances or resolve problems to the mutual satisfaction of those involved. Certified security. Oregon law requires that individuals who function primarily as security personnel must be certified by the Oregon Department of Public Safety Standards and Training, the DPSST. A person may be subject to this requirement if their primary responsibility includes any one or combination of the following duties: observing and reporting unlawful activity, preventing theft or misappropriation of items of value, protecting individuals and property from harm or misappropriation, controlling access to a premises being protected. This included checking ID at the door, detaining or placing persons under arrest, or providing canine services to guard a premises or to detect unlawful substance or devices. OLCC inspectors, police, and other law enforcement officers, when they visit licensed premises, may issue citations to both the licensee and the employee for failure to have the necessary certification. Cooperating with OLCC regulatory employees. The OLCC normally examines premises when they are open to the public. OLCC officials may inspect a business after hours only when they have reason to believe a violation of liquor laws is occurring. Licensees and permittees must not refuse to promptly admit an OLCC regulatory employee or a police officer when the officials identify themselves and ask to enter to conduct a reasonable search to ensure compliance with alcohol regulations. A licensee or permittee must never incite or encourage customers or coworkers to not cooperate with an OLCC regulatory employee. If the OLCC employee directs a licensee or permittee to call the police, they must do so immediately. Also, no licensee or permittee must ever destroy, damage, alter, remove, or conceal potential evidence. They can never refuse to give an OLCC regulatory employee or police officers this evidence when the OLCC employee or officer lawfully requests it. Liquor as a prize. No licensee or permittee will give or permit any alcohol to be given as a prize, a premium, or consideration for any lottery, contest, game of chance or skill, or any other competition of any kind on the licensed premises. This law provides exceptions for charitable, nonprofit, religious, and fraternal organizations under certain circumstances. Prohibited drink promotions. Oregon law prohibits the following alcoholic drink promotions: all-you-can-drink offers, the sale of alcohol at a price per drink that is less than the licensee's cost for the alcohol, to any person paying a fixed buy-in price, entry fee, or cover charge, such as charging a cover fee and offering penny or nominally priced drinks. Operating or permitting games, contests, exhibitions, or competitions of any kind that involve the drinking of alcoholic beverages, for example, beer pong. Pouring or otherwise serving any alcoholic beverage directly into a person's mouth, including through any device such as a bong. Permitting the use of an alcohol vaporization device for the sale of alcoholic liquor. An alcohol vaporization device is any machine or process which mixes alcoholic beverages with oxygen or other gas to produce a vaporized product for consumption by inhalation. Happy hour, or any price reductions after midnight, 12 a.m. until 2:30 a.m. Advertising happy hour outside the premises. On-premise businesses may post signs referring to temporary price reductions on alcohol inside the business as long as the signs are not visible from the outside. Oregon law requires food to be readily available only in businesses that serve hard liquor. Businesses with full on-premise sales licenses must have food available at all times and in areas where alcohol is served. It is illegal for you to discourage a customer from ordering food in one of those businesses, even if the customer is ordering only food and not ordering any alcohol. The minimum food service depends on the type of operation. Commercial establishments and private clubs are the two most common. Commercial establishments, such as fine dining, family restaurants, nightclubs, bars, etc. The food requirements are 5 different meals during the dinner meal period. A meal means a main course or entree and at least one side dish. A 3-hour minimum dinner meal period. 5 different substantial food items at all other times when alcohol is available. Examples include sandwiches, pizza, soup, sausages, dinner salads and entrees. Side dishes, appetizers, desserts, and snack items such as popcorn, peanuts, chips, and crackers do not qualify, and different sizes of the same item do not qualify as different items. Side note: if the business is not open after 5 p.m., it must offer 5 different regular meals during the required meal period, which must be at least 2 hours long. Other general requirements include the minimum number of dining seats, which is determined by the size of the business, and adequate kitchen facilities and food service employees. For more details, contact your local OLCC office. Private clubs, such as fraternal and veterans organizations. The requirements for these clubs would be 3 different substantial food items prepared on the premises. And again, that would include sandwiches, pizza, soup, sausages, etc. Once again, side dishes, appetizers, and snack items do not qualify. Other general requirements include suitable and adequate space, which includes dining, seating, equipment, implements, facilities, and employees for serving food. If and when the club is open to the general public, it must comply with the food service requirements for commercial establishments. For more details, contact your local OLCC office. In-room supply of alcohol. A hotel or an arena, such as the Rose Garden in Portland, with a full or limited on-premise sales license may provide in-room supplies for the kind of alcohol allowed to be sold under its license. These in-room suppliers are kept in small cabinets or refrigerators, often called minibars, which must be kept locked. Licensees must get authorization in writing from the OLCC before offering the service. Hotels with minibars must follow these conditions. Only service permittees or similarly trained employees may give minibar keys to guests. Keys may not be given to minors, VIPs, or guests accompanied by minors who are not their children. An employee must be 18 years of age or older to perform routine restocking of the minibar. Only a service permittee may perform immediate restocking in response to a guest request. This is equivalent of selling and serving alcohol. A service permittee will not restock if there are VIPs or minors unaccompanied by their parents in the room. It is between the hours of 2 a.m. and 7 a.m. The liquor requested is more than the people in the room could reasonably consume by 2:30 a.m. The number of alcohol containers in the minibar must not exceed 30. The size of the containers is no larger than 50 milliliters for distilled spirits, 12 ounces for malt beverages, and 375 milliliters for wine or cider. Each minibar must have a sign announcing these prohibitions. Minors and VIPs may not consume alcohol. Alcohol may not be consumed between 2:30 a.m. and 7 a.m. Alcohol may not be taken off the premises. At a minimum, a variety of snacks must be available during the hours that a guest may lawfully access the minibar. Arenas. The conditions for minibar service in arena suites are different and more complicated. You need to contact your local OLCC office for details. Licensee responsibility for liquor law compliance is the same under minibar service as it is under lounge or restaurant liquor service. A pregnancy sign is to be posted at the main entrance and entrance to the areas where alcohol is sold for off-premise consumption and women's restrooms as well. Studies have shown that if a woman consumes alcohol whilst pregnant, it may cause fetal alcohol syndrome. In Oregon, there is no law against serving alcohol to a pregnant woman, and if you do deny service for the fact that she is pregnant, that might violate anti-discrimination laws, as well as your liquor license must be posted in sight of customers. What happens if you violate a liquor law? If you violate any liquor law, such as if you were to get a DUI from this day forward, your ASC permit might become suspended or revoked. If you serve a minor, your ASC permit might be suspended or revoked. If you were to get a controlled substance conviction, your ASC permit might be suspended or revoked. And if you get a felony, the same might happen. Now, what happens if you get a violation from the OLCC? Well, you as a permittee can be fined for liquor law violations. A server will be suspended for 10 days and or $250 fine. The licensee can be suspended for 10 days and or $1,650. Not only will you have lost revenue, but you might have guests become angry who may never return. Also, you can be sure that the rumor mill will get started, and by the time it's done, it will be a whole lot worse than it really is. Have you ever seen an establishment get its liquor license suspended? This sign goes up in the window, and this sign will cost you, well, revenue. You might have guests who become angry and never return, but the worst part is people are going to talk about you. Mrs. Jones up the street is going to be saying, did you hear about that place? Oh, it was more than the liquor board. Oh, yeah, health department too. And did you know they were harboring terrorists there that had SARS and the swine flu? Okay, we've made it through Unit 5. Again, just like Units 1, 2, 3, and 4, we got a little quiz to take. Once you pass it, we move on to Unit 6.